we will be discussing with you guys today landlord tenant actions and small claims at the Magisterial District Court. Once I get the okay here to share the screen, I'll bring up the PowerPoint and we can go from there. In the meantime, however, we'd like to thank everyone for attending today. We appreciate your support, and we just ask that you leave your Zoom screens muted there until the end and when we have some time for questions. And
my name is Katie Maxwell. I'm another attorney at Walters and Galloway. Do a lot of work in the MDJ's offices here in Cumberland County and a good bit in Dauphin County too. We've got a small group today, so if we had hundreds on the call, that'd be great, and we'd ask you to keep your comments to the end. But since we just have a few of us here, if you do want to interrupt, I think you can either technically you can wave your hand through the Zoom call, or you can just shout it out. We'll be able to accommodate that. Go ahead, Michael.
All right. Sorry about that, guys. All right, so we're going to start with a brief overview of the Pennsylvania Magisterial District Courts. So here, in Pennsylvania, this is your initial court. So if there's a four-tier system, if you will, and how it's set up is you begin at the Magisterial District Court. That would be tier 1. And then if you were to appeal any matter or, waive your preliminary hearing, you would immediately go to the Court of Common Pleas. From there, you'd have an opportunity to appeal to tier 3, and that would be your Superior Court and your Commonwealth Court. And depending on what type of entity you are, it would kind of serve which court would have jurisdiction over the matter. And last but not least, we have tier 4, which is the Supreme Court. Now in PA, we have 512 magisterial district courts. There are 10 magisterial district courts in Cumberland County and about 15 in Dauphin County. They're in Philadelphia and in Pittsburgh. They have what's called Philadelphia Municipal Court and the Pittsburgh Municipal Courts. They're very similar to the magisterial district courts. They just have a different name and slightly different operation.
And everyone knows that going to Philadelphia is like going to Mars, which is why they have their own, since they're different species, they have their own court structure too. And the important thing to remember here from the, regarding the MDJs, and that's what we usually abbreviate them to, is instead of saying magisterial district judges, MDJs, is that they're a gatekeeper to the judicial system. And Michael's last bullet point on here is that the MDJs aren't required to have a law license. They just have to take an exam to demonstrate that they have some understanding of how the judicial system works. But really the whole point of that is they're supposed to take a more common sense approach to small claims litigation or landlord tenant matters, and saying like, wait, I don't really care about the legal precedents involved. I'm saying this fella owes that fella some money, and let's make this as simple and easy as possible. So they're designed to get litigants involved at a basic level that doesn't require a lot of education or background, and to sort of separate the wheat from the chaff for cases that are going up to the main courthouse, at the county seat level. So it's designed to be sort of a user-friendly process, but despite those best intentions, that's not always the case. So go ahead, Michael.
So, what kind of cases do the district courts maintain jurisdiction over? So it is, your criminal preliminary arraignments and hearings and summary criminal offenses. So that'd be like disorderly conduct, an harassment charge, or low-level retail theft and things of that nature, as well as traffic offenses. So if you get a speeding ticket, you're likely to appear in front of the MDJ. Unless something else was involved there. The municipal code violations and kind of the meat of what we're going to talk about today, and that's landlord tenant suits, as well as civil claims where damages do not exceed $12,000. So if they do exceed $12,000, you would initiate a complaint with the Court of Common Pleas rather than the Magisterial District Court.
And just to really parse that out a little bit more, you can certainly file a claim with damages in excess of $12,000 at the MDJ level, but you're only going to recover a maximum of $12,000. So sometimes if you have a case that's worth $13,000, but you don't want to go to all the trouble with filing a case at the Court of Common Pleas and you're willing to eat the extra $1,000, that might be your best bet to still file through the MDJ's office. So there's a lot that we can advise you on as to what the best use of your resources is, considering the limitations of the different courts.
Yeah, and so we're going to go ahead and jump into the landlord-tenant matters. And, you know, kind of a summary of where we go from here is I have a 5-step process here. Almost every landlord-tenant action, you have to start with what's called posting a notice to quit. And from there, after the time of the notice to quit has passed, the landlord is eligible to file a landlord-tenant complaint with the magisterial district court. And within 7 to 15 days from that date, you'll get a hearing. After that hearing, you'll have about 10 days if it's a possession judgment, or 30 days if it's a monetary judgment. And from there, you can go ahead and execute the judgment or attend an appeal hearing should the losing party decide to appeal. Kind of the basics here of the Landlord-Tenant Act, and I do apologize, I'm not sure what's going on with the PowerPoint here, is that, you know, all landlords are required to follow the Landlord-Tenant Act to evict a tenant. So, you know, whether you're the tenant or the landlord, it's important to kind of, you know, be familiar with some of the more common rules. Because, you know, a landlord just can't go into the premises and you know, change the locks, take your property, turn off the utilities, or use any other sort of self-help eviction. And, you know, a common resource online, if you're a tenant in that situation, maybe you're, you know, you and your landlord are in some sort of dispute. He doesn't want you there anymore, but you have rights under your lease. Sorry. There is a contact number with the Office of Consumer Protection that you can call for some immediate assistance, and you know, kind of protect your rights there. One of the biggest things is, and this can, you know, kind of have the whole suit dismissed, is that before a landlord can actually file a landlord-tenant action, they're required to post what's called a notice to quit. So what a notice to quit is a written eviction notice to the tenants. So this would be something like, dear tenant, I am landlord, and please allow this to serve as your 10-day, 15-day, whatever it may be, notice that you have so many days to vacate the property for non-payment of rent, or for breach of lease agreement, or, you know, or even expiration of the lease term.
Yeah, fine. No.
And Michael has the notice requirements there. Those notices are by statute. So depending on how long your lease is, or what the conditions are that you're terminating the lease are, those are the time periods in which you have to provide the notice. It's important to remember that your lease, though, can substitute those timelines. And so, you know, I know a lot of landlords out there use their own stock form lease over and over and over again for multiple properties or multiple tenants. And you should all just be careful in taking a look at that form from time to time to make sure that the notice requirement is consistent with the statute and certainly doesn't exceed the statute unintentionally, at least. So the parties can waive a notice to quit, they can shorten the time period, or they can lengthen it, but just make sure each time you issue that lease that you've updated it and it's consistent with your intent.
Yeah, and if you're under an oral lease or a month-to-month lease, you know, the standard rule under the Landlord-Tenant Act is, you know, you're required to get 10 days notice for non-payment of rent. And, you know, if the landlord should decide that, you know, he no longer wants to rent to the tenant, he has to, for reasons other than non-payment of rent, you have to have at least 30 days notice under those circumstances. And as as Attorney Maxwell discussed, it is important to if you're the landlord, to read the lease before you go to initiate any action. You may not even realize, or the tenant may not even realize that they're waiving the notice requirements, but they are in there and they can be hidden sometimes. And that at the time, other than the standard rules, so for a lease of a year, you have 10 days for non-payment of rent and 15 days for any other reason to go ahead and post the notice and initiate the landlord-tenant action. Those times can be increased and decreased depending on the language of the lease. And again, as I mentioned earlier, keep in mind, if you fail to post the notice to quit, the MDJ will dismiss the action.
And we strongly encourage you landlords out there that when you're posting the notice to quit, to take a picture of the notice posted on the front door. By and large, the majority of cases that we're seeing with tenants being evicted are with somewhat unsophisticated tenants, or in point of fact, incredibly sophisticated tenants who have been down this road before and may know a little bit more about the process than either you or I, and know that to claim that the notice to quit was not posted on their door is a sort of get out of jail free card. So we encourage you to take a picture. We're all walking around with cameras in our pockets all the time, so it's pretty easy to take that extra little step to provide some backup evidence. And
if posting the notice on the door, if the landlord and the tenant have been in dispute and you feel that there's a risk of physical harm or anything like that, or even just an altercation that could make things worse down the road, by posting the notice to quit on the door, a lot of counties do allow the constable to serve that notice to quit. Then what they'll do is, as Katie mentioned, they'll take the picture and kind of give you a form, notifying you that it was in fact served or posted. After the notice to quit is posted and the time provided therein has expired, if applicable, the complaint is initiated by the landlord with the magisterial district court in the appropriate district. So depending on where you live, there can be, I mentioned there's 10 magisterial district courts in Cumberland County. So if you're here on Main Street, you would actually, if the building was here on Main Street that you were renting, you would actually file it with MDJ Martin. And the reasons you want to file the complaint are either to recover the possession of the leased premises or get money that you're owed on rent that's overdue. And one of the things to consider when filing the complaint is you want to make sure that any type of fees that you can be awarded, whether it be late fees or attorney fees and stuff, it is included in the complaint for purposes of the judgment. Now, the contents of the landlord-tenant complaint, it's relatively straightforward. At the bottom right here, I provided a link that give you a sample landlord-tenant complaint that you can file with the magisterial district court. And it requires the name of the tenants and the lessees, their respective addresses, whether the property is residential or commercial, the reasons for filing the complaint, breach of the lease, whether it, be disturbing other tenants, kind of damaging property along the premises or unpaid rent, and so forth.
And I just do want to go back up to something that Michael said about the specific jurisdiction of the MDJs. It can be tricky at times to figure out what the right MDJ office is. Here in Mechanicsburg, you got 2 MDJs with Mechanicsburg addresses. One's for the borough, one's for Silver Spring, Hamden, parts of Upper Allen. So you should really call the MDJ's office and check. They have a software program where you can give them the address of the property at issue, and they'll be able to tell you what the correct MDJ office to file in. And it's a little bit easier to do that on the front end of things and take that time to make the one phone call as opposed to get a hearing date and get all the way to the MDJ's office and find out that you're in the wrong jurisdiction to begin with. So I really would recommend taking that extra step at the beginning to avoid some heartache and frustration at the back end of things.
Now, after the complaint is filed, the magisterial district court will send you with a notice of a hearing. So they'll schedule that hearing after the complaint is filed within 7 to 15 days. you will be provided the opportunity to, request what you're looking for in the complaint, whether that be the damages, the unpaid rent, or possession, or all of the above here. So, it's important to have those things ironed out in the complaint so the MDJ is ready to hear your case and you're ready to present that case in front of them. And so, once you're actually there and you're at the hearing, the landlords and the tenants are going to have the opportunity to call witnesses and present evidence. So, you want to, if your claim is for unpaid rent or damages to the property, you need to have some sort of paper trail to show, here's my bank statement. I stopped receiving deposits or checks for the rent on March 1st of 2020. It is now February 28th of 2021. And, I haven't had rent in 11 months. So it is important to have prepared when you're at the hearing itself, any type of agreements between the landlord and the tenants that there may have been, whether it's the original complaint or the modified agreement. And I would recommend, especially if you're looking for damages to the property, whether it's the actual unit itself that the tenant is renting, or just the overall premises in general, you kind of have photos to show that, I'm not just saying there's damages to the property, here's your proof. And of course, again, it's judge dependent, but a lot of times they want to see the copy of the notice to quit and receipts for repairs and stuff like that to actually award you the monetary amount that you're requesting for damages.
And sometimes we get jammed up a little bit that the landlord comes in and says, hey, I'm going to need to put new carpet in, and that's going to cost me $3,000. We're going to need something a little bit more concrete than your personal estimation that that's what it's going to cost. You're going to either need to have made the repairs and have the receipts for those repairs, or you're going to need to have an estimate provided to you by a legitimate provider of those services. Now, some of you bigger landlords might have in-house folks that can do that for you. And in that case, you can list your costs and your out-of-pocket costs and the hourly rate that you're paying your employees to do that extra bit of work for you. But it's going to have to be something other than just your own sort of guess as to what those repairs might be.
And to kind of add to that in terms of anybody who's witnessed the damage, or whether it be a tenant who is harassing other tenants, or maybe a landlord just kind of making something up. So you want something there, someone there to kind of back up your statement. It'd be important to, if they're willing, either get those witnesses to write a statement or, agree to appear with you while you're at the hearing to kind of have some additional support there.
And quite honestly, I don't know where all this is going to go in the long term, but presently a lot of these hearings can be done remotely, and that I think going forward, I think there's going to be much more of a tolerance for the court to consider video testimony from other participants. So probably once we all hopefully go back to normal, that the parties will actually need to be present in person, but any of these sort of extra witnesses might be allowed to testify via video or via phone. So, just keep those options open, and certainly talk to your attorney or the MDJ's office as to their preference and their tolerance for allowing those extra considerations.
One thing I should have mentioned a couple slides back before filing the complaint is, there's currently a federal eviction moratorium. And there's talks that's going to be extended until May, September, or, however long that may be, depending on what they, what the government decides. But, one of the things to keep in mind before filing that complaint, if a tenant, whether, you are the tenant or the landlord, if you fill out, there's an affidavit you can fill out saying, if I'm evicted, I can be homeless. I don't have money to get another place. I'll have to go to a shelter. I'll have to move in to kind of, move back in with my family. So me and my, my kids and husband or wife, have to move in with my family, and there's a greater risk of catching the coronavirus. If that is received before you file the complaint, and the landlord proceeds with filing the complaint, then you're entitled to damages. So that is something to keep in mind, whether you're the landlord or the tenant. That could just trip you up if you're not aware of that. Now, once you're at the hearing and you present your case to the judge and it concludes, you should have a decision within 7 days. Now, there's 3 types of judgments. That's a pay and stay judgment, a possession judgment, and a monetary judgment. The pay and stay option is if you're only bringing a landlord-tenant complaint for non-payment of rent. This is a very common complaint. A lot of times what the judge will say is, okay, I'm going to grant you, or I'm going to provide the tenant with 10 days to go ahead and make any back rent. If he fails to do so within 10 days, you can then request the order for possession and take possession of the premises. To avoid that, as the landlord, the best way to approach it is to file a complaint with, for unpaid rent and for a breach of a certain section of the lease. And what that'll do is that'll award you with a possession and or monetary judgment, depending on how the judge rules that day. So what that does is the pay and stay option is no longer available. And you have, after 10 days, you can take possession if the tenant does not appeal to the Court of Common Pleas. And you can proceed with taking possession of the premises. And if you want to execute on the monetary judgment portion, you have 30 days. So under the Landlord-Tenant Act, the tenant has 30 days to appeal the monetary judgment. And that's even if you take possession after 10 days, they still have an additional 20 days to go ahead and appeal just the monetary portion.
And when we're talking about the timeline for the judgment, by statute, the MDJ has 7 days to get back to you to issue an order, and you can track that on the Pennsylvania Judicial Portal website for docket sheets. So you're not just having to stay by the mail and wait for something to come and get you. But as a practical matter, the MDJ almost always issues his or her decision at the time of the hearing. And the only time I've experienced otherwise is when things are a little hot in the courtroom and people are emotional and volatile, that the MDJ may say, I'm going to take this under advisement. Why doesn't everyone go home? And I'm not going to issue my ruling right now. But I think in large part, they know what they're going to do, because usually the evidence is pretty clear. If the rent's $1,000 a month and nobody's been making any payments, you clearly have a breach. The other thing I want to say about the types of judgments available to you is that for many of you, you might not just want the tenant to get back on track with their payments. They may have had a long history of non-payment of rent, and you go through this process somewhat cyclically, and you just are sick of having to deal with them. In those cases, you want to ask for a money judgment, but you also are asking you should find a breach in the lease. And there's almost always going to be some wiggle room to argue that, so that you can, excuse a tenant who's been a long time problem for you. So I would encourage you to think of that as an option too, so that you're not just getting a tenant back on track only to fail again in 4 or 5 months.
So to kind of wrap up this portion of the seminar, again, we're going to just provide a brief summary here of the landlord-tenant action. You got to start with the notice to quit, unless that's been waived in the lease. You then want to proceed with filing the landlord-tenant complaint. You'll have a hearing within 7 to 15 days. And I have here at step 4, wait 10 days, because a lot of times, the main thing you want is possession. So you have to wait 10 days to see if they're going to appeal to the Court of Common, if the tenant or the landlord, if you will appeal to the Court of Common Pleas. And if not, you can go ahead and take and execute your award there in step 5. Or the next thing that'll be scheduled is the appeal hearing after a complaint is filed.
And waiting those 10 days is a little bit more involved than just waiting the clock out. You're going to have to go back and get an order of possession signed by the MDJ. So there has to be an affirmative step made by us or you as the landlord in order to be able to proceed to step 5.
All right, now we're going to kind of transition from the landlord-tenant actions and talk about the small claims that can be brought with the magisterial district courts. We're going to start again, as we did with the landlord-tenant portion of the seminar, and kind of discuss the brief summary of the small claims procedural steps here. Unlike the landlord-tenant actions, you do not have to start the action by posting a notice to quit. You file a civil complaint with the magisterial district court. Again, a hearing will be scheduled in about 7 to 10 days. And if judgment is awarded, the opposing party will have 30 days to go ahead and file an appeal with the Court of Common Pleas. After that 30 days is up, you can execute the judgment awarded or attend the appeal hearing, depending on what happens throughout that 30 days. And as Katie said, it's much more than just kind of sitting there waiting, and then you get a paper in the mail saying, here's your judgment. You do have to request an order of execution. So the small claims in the PA magisterial district courts is unique because they want to make it accessible to anyone who has kind of a claim that is not in excess of $12,000. So what they do is, no attorneys required here. There are no jury's trial, and as long as you're 18 years or older, you can file with the magisterial district court, and businesses are allowed to bring these types of action as well. But I believe an attorney is required to represent them in these types of matters.
That's correct. So if you have a real estate company that holds a bunch of rental properties and you're suing in the name of the company, you have to have an attorney in order to proceed in the MDJ courts. And certainly no attorney is required. However, it is commonplace to actually have attorneys representing parties in the MDJ courts.
And the types of small claims that the magisterial district courts typically hear are for property damage. So, you may have a contractor come to your property and, you want him to do A, B, and C, but in the process, he damages your bathroom sink. In total, with the labor and the cost of replacing the sink, it might be $1,500, and this would be the appropriate court to bring that type of action to go ahead and recover the money that you're owed. They also hear, minor contract disputes, dog bite injuries, failure to fix car and home appliances and other properties, repayment of loans, security deposit issues with landlord-tenant actions and things of that nature. Now, some of the things that they do not hear are divorce or child custody disputes, bankruptcy actions, and ejectment actions. Also, it's important to point out, we just discussed the landlord-tenant actions. So whenever you're going to file a landlord-tenant action, you have to use a landlord-tenant complaint. You do not want to use so if you were to go to the MDJ's website, they provide you with kind of sample complaints that you're able to fill out. You would not want to use a small claim complaint to fill out a landlord-tenant action because it will be dismissed.
And I want to talk about that ejectment action that Michael says are not included in the MDJ's jurisdiction. In order to file a claim, it either has to be a small claim under the $12,000 or a true landlord-tenant action where you have a lease, whether it's written or oral. You can't just have your buddy come live on your couch for 6 or 7 months and ask him to leave, and he refuses to do so, and then you file a landlord-tenant complaint, because there is not that landlord-tenant relationship. He is essentially just a squatter at this point, and there seems to be a bit of a hole in the MDJ's repertoire or jurisdiction for these types of cases. It would make sense, in my opinion, that an MDJ would be able to hear the same type of issue, but after some false starts on our end, we've learned through experience that an ejectment action, which is what those squatter type issues are, needs to go to the Court of Common Pleas, which does create a little. It certainly creates a level of complication to the whole process. It would be easier if you could do it at the MDJ level, but you're going to need to go to your county seat for that.
Now, as I mentioned, to kind of initiate a small claim with the magisterial district court, you're going to start by preparing a civil complaint, which can be found on the MDJ's website. It's just one sheet of paper. You can attach more if you need to. But basically, you need to make sure you have the correct names of the parties and the addresses, and you want to include details about your claim. For example, person A runs this company. I hired him to come here do work at my house on said date. On said date, he arrived, and through his fault or whatever the cause of action may be, you want to go through and describe how you were injured, whether that be monetary or actually physically injured, and you want to look to see or to include the type of award that you're looking for. And then in order to go ahead and file that complaint with the magisterial district court, this is kind of the jurisdictional issue that we were talking about earlier. You need to file it in the court where the defendant resides, where the actual injury took place, or if it's a business, where that business is registered. So again, if the business was registered here in downtown Mechanicsburg, you would want to go ahead and file with MDJ Martin just right down the road.
And certainly that allows you the choice of what MDJ to file with. It doesn't have to be the same MDJ for all of those, obviously. So at that point, it's at your convenience.
Now, just like with any suit in Pennsylvania, you have to file your claim within the appropriate statute of limitations. I have an example here for breach of contract in EA that is 4 years. So that would be 4 years from the date of injury or the date of the breach of the contract. So let's say that's on today's date, February 24th of 2021. You would have to file by February 24th of 2025 in order to have your case heard by the magisterial district court. Now, most magisterial district courts do not require the defendant to actually file an answer to the complaint. That is different than the Court of Common Pleas. If you were in the Court of Common Pleas, they would have 20 days to file an answer. And if they fail to do so, you can go ahead and file what's called a notice of default judgment and proceed with actually executing on that judgment if you don't hear anything within that time. This is not required at the magisterial level. Now, typically, the defendant has 5 days until the date of the hearing to file any type of answer or counterclaim that they may have against the plaintiff who filed the complaint.
Michael, do you have anything on the notice to defend?
Yeah, so, after the complaint is filed, the magisterial district court will go ahead and send the defendant what's called a notice to defend, and that'll provide the hearing date. That's to let them know that a suit has been filed against them, and, they have the right to file an answer or a counterclaim if they choose to do so. And the hearing is scheduled for, date A or date B.
The extra thing I want to add to that is if you are being sued in an MDJ court and you get a notice to defend in the mail, there's going to be a court date associated with that, but the letter is going to say, contact us if you intend on defending. Because so many cases that go through the MDJ courts are no-shows and the defendants fail to appear because the stakes are so low that they'll schedule 10 hearings for the same time and only space them out appropriately for the length of time required for a hearing. If the defendant contacts them and says, no, we're disputing this, we're going to come loaded for bear to have a hearing. So you need to pay attention to those letters that you get from the courts and the details included in there to make sure you're doing the right thing.
Next, similar to the landlord-tenant actions, once you're at the hearing, you have the opportunity to present evidence and call witnesses to establish your claim. How was the contract breach? What was the actual contract look like? Do you have photographs of the work that was performed? Do you have statements to show that you paid for the work or that the work was not paid for? What kind of things can you introduce to the magisterial district judge to have him rule in your favor? It is important to go ahead and get that background and keep any original documents you have to kind of solidify your case. And then, using that information and, presenting your argument to the court after you've called your witnesses and so forth, and had a chance to, counter anything that the defendant may have said, you want to, have a statement prepared to present a closing argument to the MDJ as to why you feel that, your case should win.
We're probably going to talk here at the end about the appeal process from an MDJ court, and I'm sure Michael has a slide on it, but the long and short of it is all cases from the MDJ are automatically appealable to the Court of Common Pleas, and at a de novo basis. So it means you start all over from ground zero, and it's like whatever happened at the MDJ's office didn't happen. But what I think is important to remember is that these MDJ courts are still part of the greater judicial system, and any testimony provided to an MDJ is also provided under oath. Unlike a court or a hearing at the Court of Common Pleas, there's no court reporter at the MDJ's office recording and typing what is said. You have the ability to record the hearing, and sometimes it's as easy as just getting your cell phone out and recording it on your phone, so that there is a record going forward of what each witness testified to, and that you could then later on use that to impeach a witness if the case ultimately went to a trial at the Court of Common Pleas. If you want to get fancy with it, and we do this frequently, you can hire a court reporter to come in and type up all the things that are being said. And it certainly makes the process look and feel a lot more formal and serious, and is a good option, particularly if you are concerned that someone is ultimately going to file an appeal.
And again, similar to the landlord-tenant actions, you're either going to receive judgment at the hearing or no later than 7 days. It may be a little longer than 7 days if there's a kind of issue with the postal service, but it shouldn't take that long. And as Attorney Maxwell discussed, you do have any losing party at the MDJ level does have the right to appeal within 30 days to the Court of Common Pleas. For whatever reason, if there is no appeal to the Court of Common Pleas, 30 days following the entry of judgment, the plaintiff can request what's called an order for a writ of execution or a writ of attachment. A writ of execution would be, you would request a writ of execution if you were looking to recover property that belongs to the defendant that you could turn around and sell. Now, a writ of attachment is kind of similar to garnishing wages. You would actually file that with the bank if you were to have a check from the defendant with what's called a interrogatories to the garnishee. And there are exemptions, but if funds are available to go ahead and satisfy your claim, they will award you with that. And if they no longer bank there or they don't have the money in there, those answers will be provided in the writ of interrogatories to the garnishee.
I want to talk a little bit about litigants' decision-making process and where they should file. So, as we said, you can file any claim worth less than $12,000 in the Magisterial District Justice's office. However, you can also file at the Court of Common Pleas, and there isn't a threshold that a case has to be worth in order to warrant a filing there. And so, as a litigant, you should consider your options in those two choices and determine, what the best use of your resources is. If you're looking for a quick and fast resolution involving a party that you don't think is going to fight back very hard, then certainly it's easier, it's quicker, it's more familiar to file at the MDJ's office. If you're going to have or anticipating a knock 'em down, drag 'em out fight, and you know that whatever happens at the MDJ's office, they're going to appeal, then you should really consider and perhaps talk to an attorney as to whether the best bang for your buck isn't to just go ahead and start a case at the Court of Common Pleas, because as we've said, every case can ultimately end up there on a de novo appeal, and now you may have wasted 6 or 7 weeks at the front end dealing with the MDJ's office before you're ever really able to get any teeth in the judicial system into the case at all. So you have a lot of options when it comes to deciding where to file, and you should consider those options carefully.
And to kind of sum things up here, as we did in the beginning, it's a simple 4-step process when dealing with the small claims at the magisterial district court. Begin with filing the complaint. Your hearing is scheduled within a week or two. You go ahead and present your case and all the evidence you have to the judge, along with witnesses to establish why you should win the case. And you have to wait about 30 days to see whether or not the losing party is going to appeal to the Court of Common Pleas, or if, you can go ahead and execute the judgment.
So before we get to some of our other matters coming up here, we got a couple of you on the call, and certainly want to give you the opportunity to ask any questions if you do have any. And like I said, we've got a small enough group that we can answer some specific questions that might be individual to each of you. So shout away if you have anything.
And you may still be muted if you do have questions. Just make sure you go ahead and unmute that there.
Well, Michael, I think you covered everything for everybody. So certainly feel free to get a hold of us if you have questions going forward or want us to explain any more details to you about the MDJ process, or particularly the landlord-tenant procedure. You can find our email addresses on our website. I believe you probably are already on our email list if you got notification of today's webinar. But we have another couple of matters coming up here in the next month or so. Looks like my partner Fisher-Greene is going to do some estate planning and trust planning presentations. She usually gets quite the attendance. She sets the attendance records here for these webinars, so she knows what she's talking about. She's very effective, so feel free to check those out. And we are planning more of these, so keep a lookout in your email for some other topics that might interest you coming up in the next few months. And thanks for joining us this afternoon.
Yeah, thank you, everyone.